24 hours ago, the Supreme Court affirmed the constitutional power of the president to declare a state of emergency in Nigeria to prevent a breakdown of law and order. That part seems clear enough. It is the next bit, the part about suspending elected officials, that has been left open to interpretation and ignites controversy. Well, some media reports say that the court also affirmed that election officials may be suspended during emergency rule, but alluding to the deliberate silence of the Constitution on the spirit of Section 305, the Supreme Court says that the exercise of such powers remains subject to the judicial review to prevent arbitrariness and abuse. As expected, the PDP has condemned the judgment, warning that its interpretation could pose serious risks to democracy in Nigeria. Other dissenting voices say it does not bode well for the future of federalism. The ruling followed a litigation filed by Adamawa State and 10 other states governed by the People's Democratic Party over the emergency rule imposed by the president on Rivers State. That was in March. Well, to give us some clarity on that ruling, I'm joined now from Lagos by the renowned senior advocate of Nigeria and human rights lawyer Femi Falana. Glad to have you join me on Prime Time.
Thank you very much.
All right, well, justice denied, they say it's justice delayed, but we'll get to that a little bit later in the course of the program. There are only 4 ways by which any executive officer can be removed from office, either through that incapacitation, impeachment, or resignation. This was Supreme Court's ruling of 2008 concerning Atiku. But when Justice Idris, in his judgment, he said the president can use his discretion, as Section 305 does not specify the exact nature of the extraordinary measures. What is the implication, or what could be the implication of this judgment to years ahead to the polity in Nigeria here?
Well, I think in fairness to the Supreme Court, the justice that delivered the leading judgment, the Honorable Justice Mohammed Idris, it did send out what is regarded as summary judgment. Unfortunately, most commentators have not bothered to read the judgment. Yes, there's no doubt that the court did say or did confirm the powers of the president to adopt extraordinary measures to restore law and order in any state where a state of emergency has been declared. There was no doubt before now that the president could deploy forces or take other steps to restore law and order. What has always been in controversy is the extent of the powers. And the Supreme Court made the point that the provision of the Constitution, Section 305, has not set out the extent of the powers that the president can exercise. But in the majority judgment, the Honorable Justice Idris did say that unlike the constitutions of India and Pakistan, Section 305 of the Nigerian Constitution does not expressly confer power on the president to assume or temporarily displace executive or legislative institutions of a state. And his lordship went further to say that this omission In other words, the omission to empower the president to dissolve democratic structure is deliberate, and that it reflects Nigeria's constitutional commitment to federalism and the autonomy of state governments. Earlier than that conclusion, the court had also heard that the three tiers of government in Nigeria, the federal government, the state government, and local government, are independent, autonomous tiers, and that none is superior to the other. In other words, the Supreme Court was simply following its earlier decisions to the effect that governors of states cannot suspend or remove democratically elected chairmen and councillors. In like manner, the Supreme Court has now reiterated its position that elected structures, elected public officers cannot be removed, cannot be dissolved or suspended or displaced except in accordance with the provisions of the Constitution. So I would therefore urge Nigerians to study the judgments very well. In fact, for the avoidance of doubt, in what has been regarded as a minority judgment, the Honorable Justice Obande Ogunya did not in any way prevaricate. You know, his lordship made the point that there is no provision of the Constitution that allows or that empowers the president to remove elected public officers. What the Supreme Court did not do, and I think this was deliberate, was to pronounce on the merit or otherwise of the imposition of emergency rule in Rivers State. It might be said that it has become academic because the governor has since resumed his duties. I mean, I'm talking of Governor Fubara. But the other confusing part of the judgment is where the Supreme Court challenged the local standard of the plaintiffs, that is the 11 attorneys general that filed the case. I'm saying this is worrisome because in the case of Attorney General of the Federation and Attorney General of Abia State and 35 states, decided in July last year, the local standard of the Attorney General of the Federation was challenged. But the Supreme Court said no, that the Attorney General has the local standard to file the action on behalf of the 774 local government. So if that was so, I was of the opinion that the court should have been consistent and uphold the local standard of the 11 attorneys general that filed this very historic case.
Okay.
But unlike 2004 and 2006, when emergency rule was challenged in Plateau State and Ekiti State, this time around, the Supreme Court went beyond its previous position by simply saying here, since you have no local standard, the court has no jurisdiction. But the Supreme Court went further, and it's only the Supreme Court that can do that by making policy pronouncement on Section 305 of the Constitution. Thank you.
All right. Well, so what you're saying, because I mean, you were going ahead of me. Let me put it like that. So I wanted you to speak to the issues you're raising already, that the plaintiffs did not demonstrate the existence of an actionable dispute between them and the Federation to warrant the exercise of the court's original jurisdiction. You want to explain that further, what they were trying to say?
Well, the court is trying to say that with respect to the imposition of emergency rule in Rivers State and the suspension of Governor Fubara and other elected officials in that state, the court was saying that action of the president or the decision of the president on Rivers State do not create a dispute or did not create a dispute between the plaintiffs, that is the 11 attorneys general, and the federal government, the attorney general of the federation. But the governors did say that any governor in Nigeria, I mean the plaintiffs did say that any governor in Nigeria has interest and then an actionable case with respect to what happens in Rivers State. More so that the Attorney General of the Federation, a few days after the declaration of emergency, did say that we have only taken care of Rivers State and we can deal with any other governor. So that already created fear, rightly so, in the minds of the plaintiffs by saying, it could be our turn, therefore, it is better to prevent the political holocaust that may occur in our states. So, with profound respect, I do not agree with the Supreme Court that there was no dispute between the plaintiffs and the federal government. Certainly there was a dispute. And then the governor do not have to wait before taking an action. They don't have to wait for their own removal or declaration of emergency in their state before rushing to court to prevent what they regard as constitutional heresy.
Well, one really wonders, I mean, you disagree with the Supreme Court, and that's the apex court. And one really wonders, if that's the case, and this is the apex court, how is the anomaly, because that's what you're painting, how is it going to be corrected?
Well, you know, when you lose a case in the Supreme Court, you simply tell your client, if they ask you, where do we go from here? You say, that is the end of the road. Appeal lies with the Almighty God. You know, but in this particular case, what we may have to do, the Supreme Court has already provided some guide. So that when next the President of Nigeria has cause to declare a state of emergency, there shouldn't be any controversy. Again, as I did say, the leading judgment of the court has stated very, very clearly that Section 305 of the Constitution does not confer power on the president to temporarily displace executive or legislative bodies in a state. And for me, that is the most important part of the judgment. The other areas that we disagree with has to do with whether the plaintiffs have local standard or not, whether the court has jurisdiction or not. But in spite of dismissal of the case, the court still went further to dwell rather in extenso on the merit of the case. And that will provide a guide when next the president of Nigeria
wants to take such
may
an
have
action.
cause to declare a state of
All right.
emergency.
This
That's the way
is quite...
I look at it.
Okay, this is quite mind-boggling to some of us. If the Supreme Court, the final arbiter, says it doesn't have jurisdiction, it gives cause for a lot of concern. Could you help explain how this can be so? Has there been precedents anywhere, either here in Nigeria or anywhere at all in the world? And what were the extenuating circumstances that necessitated that precedent? The question of Supreme Court saying we don't have jurisdiction. It's mind-boggling, maybe because one is not a lawyer. So
No. I think what the court is saying, and we must learn to fight when our rights are violated. In the case of Plateau State, it wasn't the suspended governor that went to court. In the case of Ekiti State, it wasn't the suspended governor or legislators that went to court. In the case of Rivers State, the governor and the legislators did not go to court. So if you agree with the anachronistic doctrine of locus standi, that unless you are personally affected in an action taken by the government, you are bound to disagree. Because in these days of public interest litigation, any concerned member of the public must be able to challenge any constitutional derelict or violation. And it's in the interest of all of us. The Supreme Court had moved away from the case of Abraham Adesanya and the president. That place occurred in the Second Republic. Even then, there was a minority decision by the then Chief Justice of Nigeria, the late Justice Fatai Wulem, who did say that the court must open its gate and allow aggrieved citizens to ventilate their claim. And that it was better to do that than to drive them underground where revolutions are made. The Supreme Court went further. In the case of Fawemi and Akilu number 1 and Fawemi and Akilu number 2, in fact, in number 1, the Honorable Justice Esho put it in its own usual, manner by saying, whereas in the United Kingdom, in England, the word brother means your blood relation. But in an African setting, where we have the extended family system, we are all our brothers' keepers. And that therefore, the Supreme Court has departed from the narrow path hitherto trodden on locus standi by now embracing public interest litigation. The Supreme Court also reiterated that position in the case of Center for Air Pollution and NNPC. But recently, the Supreme Court appeared to be moving away from public interest litigation by now insisting that before you can approach the court, the injury suffered by you must be higher than that of other members of the public.
All right.
It makes a mockery of the concept of public interest litigation.
Okay.
And Nigeria is the only country now, almost the only country in the Commonwealth that is going back to embracing, the very, very restrictive concept of locus standi. And I do hope that our courts, just like it did last year in the case of local government autonomy, by recognizing the locus standi of the Attorney General, it ought to have also given locus standi or recognized the locus standi of the 11 Attorneys General that approached the Supreme Court, on this matter.
So then there arises the disturbing question of How do we then get this corrected? How do people like you get the Supreme Court to go back to what you're discussing? But that's not where I'm going to. That's not where I'm going to. You may address it when I ask those questions. Let's address this issue of justice delayed is justice denied. This case took about 9-10 months to adjudicate on. You know, that's one. And then why in the first instance does the Supreme Court give judgments that leave room for those who brought the case to give differing or different interpretations? How unhealthy or otherwise is this for our polity? Can you take those questions in your stride? Then it's silk.
Yeah. Well, the last one, I think we all need to read judgments of court so that we can understand the reasons for the decisions of the court. And again, as I did say in this case, as soon as the news went out yesterday that the case was dismissed, the impression was given that the Supreme Court had endorsed the suspension of elected governors and legislators. I've taken my time to read the judgment over and over again. Why the court recognized the far-reaching powers of the president whenever a state of emergency is declared. The president has the power, enormous power, to ensure that law and order or constitutional order is restored. But that does not empower the president to remove elected governors and legislators. But that came out very clearly in the majority judgment and the minority judgment of the Supreme Court. Now, having agreed with that, we then move to the next thing. When a situation like this occurs, where do we go? I mean, where do you go from here?
Exactly.
It is to take advantage of other cases, similar cases. And I do know that there are many cases currently pending in the Supreme Court where the question of local standard will be raised again. I mean, I'm just filing a case now. I lost a case and yesterday on the question of local standard. The High Court said I had local standard to challenge the diversion of the funds that should be paid to, the Federation account. But the Court of Appeal said, oh, Mr. Falana, we commend your effort. However, in view of the recent decision of the Supreme Court in Fawemi and Okonjo-Iweala, you no longer have local standard. Again, we are taking that to the Supreme Court so that the Supreme Court will have the opportunity
to correct itself,
to review its position on local standard in the interest of the public, in the interest of all of us. Because if you lock up the gates of the court, citizens will be compelled to take other action that may threaten the security of the state, law and order. And so that is why the question of, and I think it was the Supreme Court again, I think in the case of A.G. Bende and AG of the Federation, that the floodgate should be opened
quickly
so that the courts can perform their constitutional role in the Constitution to act as arbiters in dispute between citizens and citizens, as well as citizens and government.
And government. Yeah, quickly, you didn't address the issue of, I don't know, so many things to talk about, but you didn't address the issue of, how did I say, justice delayed is justice denied. 9 months, 10 months. And then, of course, the question of the fact that this had occurred, the fact that the elected governor, deputy, members of their assembly were removed, which was wrong. How do you correct, How do you correct such ills? It's been done, it's wrong. How do you correct them? And then the question of justice delayed is justice denied.
Again, what I think should be done next time is for what the Supreme Court is saying is that those who are affected should pluck up the courage to challenge their unconstitutional removal. I mean, if it had occurred in Lagos when President Bola Tinubu was governor, he certainly would have gone to court. Because if you look at all the actions fired by the Lagos state government against the federal government and cases instigated by the Lagos state government against the federal government, they were all meant to strengthen the democratic process. In fact, I can say without any fear of contradictions that, but for some of those cases, state governments might even have been declared bankrupt. Because those cases that were won by the Lagos state government had defined constitutionalism in Nigeria. Whether state governments can create local governments, whether state government can approve building plans in their states, and so on and so forth. The federal government was totally in control of the affairs of our country, because we're moving from a unitary system of government under the military junta to a civilian dispensation. But Lagos state government mobilized other states to challenge the attempt by the federal government to extend the tenure of chairmen of local government, to conduct local government elections, on the creation of local governments, seizure of local government funds, control of physical planning in the states, and so on and so forth. And those cases are redefined. In fact, I say those cases have promoted restructuring by litigation. Other states have also followed suit. And that is how we have been able to resolve a lot of disputes caused by the military structure. Because the constitution we have is a unitary constitution. But through cases filed by state governments and some concerned individuals, we have been able to redefine federalism and be able to extricate federalism from the unitary structure in Abuja.
Case that they said you don't have the local standby. As you go to the Supreme Court, one can only wish you luck that you get a good judgment. Thank you so much, Femi Falana, there, Senior Advocate of Nigeria, renowned Senior Advocate of Nigeria and human rights lawyer, for being on Prime Time. Thank you so much.